We're going to obviously look at those two topics. We'll begin with force majeure. And as you can see, we'll be talking about a series of key considerations that's focused typically around how we draft these clauses and the key elements to look out for in these clauses if you come to review them with a view to amending as part of negotiation or also as part of litigation, as we'll be discussing later on. Well then, unsurprisingly, having set out what those key considerations are from a drafting point of view, we'll go on to discuss a variety of cases, and we'll look at one or two of the recent topical issues that we see, and in particular with a strong emphasis on the impact of COVID-19, look at a very recent case from 2022 with regard to that issue. At the end of that discussion, which will be about the first half of the session, we'll then look at sort of key steps to take. So whether you are looking to litigate or defend litigation, we'll look at the sorts of things that you need to watch out for, the sorts of things that you would use to sort of back up your respective arguments. Now, the other half of the seminar will be around the topic of frustration. We'll look at the usual sorts of considerations there. We'll have a brief reminder of what the rules are, when those rules are likely to apply, and then we'll look again through the prism of several cases, one to do with COVID-19, or two, in fact, to do with COVID-19, and one, in fact, to do with Brexit. We will look at sort of how the courts are interpreting the rules around frustration in the current climate. Now, what then follows is sort of protracted correspondence, which I've simplified somewhat because we don't have all morning to talk about this case, interesting as it is. So you'll see here, the letter of the 20th of March, essentially, again, you can read the whole thing if you want to, but what EPCR are saying is that because of COVID-19, we are required to postpone semi-final and final matches in terms of the European sort of Rugby Cup. The risk on the next slide that Salaam might be unable to undertake passenger flights from Muscat or elsewhere in Oman for some significant period, or that there might be a dramatic and long-lasting fall in the demand for air travel more generally, were risks inherent in the commercial operation of the aircraft and assumed by Salaam under the aircraft leases. If total destruction of the aircraft or dispossession through requisition do not relieve Salaam of the obligation to pay rent, then it's highly improbable that the matters relied upon by Salaam in this application have this effect.